Judge Chutkan in the Donald Trump January 6th prosecution set a pretty insane trial date, March 4th, 2024. Well, sitting here scratching our heads saying, you know, that's pretty soon. That's like right around the primaries of the 2024 election. In fact, it's one day before the primaries, which are going to be taking place on Super Tuesday on March 5th. Isn't that convenient? So March 4th is going to be the trial in DC. Super Tuesday, when many states around this country are voting, going to be the day afterwards. Very convenient timing. Now, Judge Chutkan released a trial order. We're going to go through that. We're also going to see what happened in court because Trump's lawyer put up a pretty big fight here in court today saying this was outrageous, insane, unreasonable, because there's no way that Donald Trump's defense team can possibly prepare in this short amount of time. Remember that the government wanted this trial to happen even sooner. They asked for a January date. I was saying it was actually a December date because that's when they wanted jury selection to start. But the trial with opening arguments, they wanted it to start January 2024 from their perspective. Trump asked for 2026. Why? Because they have 11.5 million documents in the initial batch of discovery that they have to review. It's an insane amount of documents, really without precedent. Here is what it looks like on a scale. If you were to print out all 11.5 million pages of documents and stack them up, it would be 8.5 Washington monuments. This is the Washington Monument. You've been to Washington, D.C. or seen pictures of it. That giant tall building. It's huge. 555 feet. If you stacked all of the papers up, it would be, that's just one Washington Monument. Trump has 8.5 of them, all right, in physical paper documents. That doesn't include audio recordings, video recordings, spreadsheets, documents that don't have pagination, all sorts of technical readouts, right, all the other things. I would imagine there's books in there, treatises in there, they're referencing all sorts of insane things. You've got, that's just what they're giving to Trump in their initial production. Remember that in a criminal case or any case, you have discovery. They've got to exchange information. And it never, ever, ever is the case that the person who receives the information says, oh, perfect, that's everything I needed, thank you. We'll get to work and look at this. We don't need anything else though, have a nice day. Never. You always say, nope, you're missing this, I've got questions about this, I want to interview that guy, I want to do this, that, and the other thing. So Trump's people would come back on this and they would say, all right, you've got 11.5. Well, you reference this person and who's this and what agency said that and where'd this report come from? I need all of that. So 11 million, if you extrapolate that, let's say, you know, you get one hint in the original batch that cues you off to 5 additional pages of whatever it is, which is probably a low estimate. You're looking at like 50 million pages of documents when you're requesting supplemental discovery and you go round and around and around. It's nuts. There's really no precedent for this. And this is why Trump's defense put up a fight. And here's what they argued in their motion. They said, this is ridiculous, Your Honor. 11.5 million pages is insane. There was another case in this country called Walmart versus Visa. It took 7 years to litigate that case, 7 years. And they want this happening basically within 8 months, give or take. 7 years. And that involved 5 million pages of documents. It's an insane amount. So if they wanted trial to happen before January, that would have been 100,000 pages per day. That is reading. So you have to think about lawyers reading all of this. Like this is lawyers doing this. That is the entirety of War and Peace, cover to cover, 78 times a day, every day from now until jury selection. Now the judge gave them an additional 2 months, right? So it was supposed to be January. Their calculations were for January, but she said, no, you're right. You need a little more time. So they bumped it out. So I don't know how many times that is now. So now that means you've got to read it, what, 68 times a day? I don't know. We're not going to do the math here, but it's crazy. That's just reading it, not analyzing it, organizing it, integrating it. So let's say Trump hired 78 lawyers. They would have to read Tolstoy's book once per day, every day until jury selection. Yeah, 7 days a week. You'd have no break at all, nonstop. And that's just reading it. So then you got to organize it. And then you're going to have questions about it, right? They're all going to have questions. Hey, who is this? What's this on page 5? I got a question. Hey, I want to interview this dude on page 35. Hey, what's this question about this character? Nonstop. So obviously that's insane. Now they gave them, to be fair to this judge, by pushing it back a little bit, it's probably not 78 lawyers every day reading the book. It's probably what, like 70, maybe 70, 65. I don't know. Because they got another 2 months. Do the math. Probably not. It's actually probably like 75, right? It's a lot. So if you stack it all up, it would stretch 5,000 feet into the sky. Here's what it looks like. That's just the documents. But the government still has more materials. They're going to have more stuff. And and they cite it all, right? More stuff is coming. They're going to continue to produce the defense. This is just their batch. Trump's people have not even asked for anything yet. So the judge took a look at all these numbers and considered Walmart versus Visa and their 7 years of litigation, and she decided to do the following. Judge Chutkan issues the pretrial order. With all of that being said, very short order, a couple pages long, 3 pages, filed against in the case of the District Court, United States of America versus Donald Trump. They say trial is going to begin on March 4th at 9:30 a.m. 2024. All pretrial motions, excluding motions in limine, which are the preliminary motions that you file kind of last minute to preclude somebody from testifying or to keep certain evidence in or out. We cover a lot of them here. Shall be filed on or before October 9th. Oppositions due by the 23rd of October. Replies due by November. Any character evidence no later than December 4th. Government shall provide notice if it intends to offer it. Motions in limine and suppression motions shall be filed on or before December 27th. Man, right in the holiday season, huh? Shall be oppositions by January 9th. Replies by January 22nd. Now, voir dire is going to start. Oh, this is curious. Yeah, so they're going to start jury selection January 15th, but then the trial's not going to start. Oh, no, I'm sorry. This is when their questions are due. Okay. So counsel shall jointly submit both a short narrative and then file their proposed jury instructions by that date. To the extent that the parties seek to use pattern jury instructions from the current Red Book, let us know. Government's under ongoing obligation to disclose exculpatory information. This is your Brady material. If the government knows anything that is tending to prove Trump's innocence, then they've got to disclose that. On or before February 12th, expert witnesses disclosed by December 11th, exhibits filed with replies no later than January 9th, witnesses exchanged final lists by February 19th, and then jury selection procedures, they'll figure that out at a later date. So jury selection at a later date. Okay, so very, very fast, right? A lot of this is standard stuff, but it's just happening very quickly, very compressed time frame. And this is not something that the Trump team is happy about. We know that the Democrats, in my opinion, are largely doing this to try to squeeze it in before the election, because this is what they're going to parlay into an excuse to keep Trump off the ballot, right? Once he's a convicted felon, especially on the J6 case, then they're going to say he's guilty of insurrection, and that's going to justify removal from the ballots. They're going to say he is not qualified, just as though he's under the age of 35, or just as though he's not a naturalized, natural-born citizen. Insurrection just disqualifies him, and the felony conviction will supplement that. So we know that's what the judge ordered. Let's take a look at how this all went down in court. Here's what she says. Out of D.C., Judge Chutkan coming out onto the bench. All rise. Oh, gosh. All right. Please be seated. Judge walks over to the bench, and Chutkan's wearing a bright blouse underneath her black robe. You look over at the government's prosecutor's desk. Guess who's there? Molly Gaston. Now for the government, looks like it's just her, but for the defense, we've got a couple of other lawyers. John Lauro, Todd Blanche, and Greg Singer, all here for Donald Trump. Trump is not in attendance. His presence was waived. So Judge Chutkan comes out. She says, all right, good morning, everybody. Now, we're here today on a trial setting conference, but before we jump into the trial setting, I want to discuss Trump's motion to exclude 25 days between Trump's initial appearance on 8/3. Remember, this was an early August case under the speedy trial rule. And this is Trump saying, we don't need that time. We're not in any hurry here. Okay. So don't count the days. Don't start the clock against us and tick those days off for speedy trial calculations. We don't need them. We waive them. We just throw those in the garbage. And they say, please exclude them from our calculations. The judge says, well, you guys, a defendant's trial, it must occur within 70 days from the date of the initial appearance. But we can exclude some days lost to delay. And she says, well, taking this into account and all the reasonable time between the arraignment and this hearing, I do find that approximately 25 days will be excluded, saying that there were some delays and taking into account, so she waived some time. Okay, we're done with that issue. All right, let's get, any objections? Then no, fine, 25, okay, whatever. All right, now, with that out of the way, she says, now we're here for a bigger reason today. We've got a set trial in this case. Says, all right, government, you're proposing here today a January 2nd, 2024 trial date. Is that right? Yeah. And you say you want voir dire, jury selection, that you want that to begin in December, right? Yeah. And Mr. Trump defense team, let me be clear, you guys are asking for April 2026. Is that also true? Yes, that's true, Your Honor. She says, well, these proposals are obviously very far apart, and for reasons I'll discuss shortly here, neither one of them are acceptable. She opens up her book and she's dragging out a memo. Looks looks like she's got some case law. Everybody goes, oh, great. He says the Speedy Trial Act case law, it provides that the appropriate judicial officer at the earliest practicable time shall, in consultation with the government, set a trial for a certain day to ensure a speedy trial. And so she's reading through the rules. She says factors that may influence a speedy trial. Complexity of the case. Good one on this one. Continuity of counsel concerns. Continuity of counsel, like is a counsel, going to be on the case for so long that they have to change or whatever. Also, concerns for effective preparation. Like, remember, the government has been investigating this case since January 6th. They've had years to prepare this case. Does Trump get any of that amount of time since this was just filed in August? Judge says, well, and given those factors that we've just analyzed, says Donald Trump, like any defendant, will have to make the trial date work regardless of his schedule. So she says, I don't care if he's got campaign events. I don't care what he's doing. Just like if this case involved a professional athlete, for example, it would be inappropriate to set a trial date based on her game schedule, which is obviously true. And I like how she used the female pronoun there. In her mind, it's a WNBA player. It's like, obviously, why would you care about if they're in a game or not? Who cares? Obviously. But if it's another athlete that people actually care about, then maybe she would want to care. So it's interesting. Anyways, that's just me inserting that. But so she's saying, look, if you're a doctor and you're in surgery, if you're a teacher and you've got classes to teach, if you're a plumber and you've got a big job, we don't care. We're the courts. Show up here. She says, and look, this is like a little bit different. Donald Trump is running for president, which is a little bit different than a professional athlete. Just to be clear on this, right? One, the position that he's running for implicates the Justice Department. Okay, one of the things he's running to do is to reform the Justice Department. So part of the political process is necessarily to comment on what I would argue is an illegitimate, corrupt Justice Department, which includes this court and what we're seeing out of DC. Sorry, but it's true. And so this has to be something that he can comment on. Otherwise, his free speech rights are being trampled all over, and the political process that we're due as American citizens is non-existent. So to compare it to just a professional athlete that doesn't have any of those same factors or any of those same considerations is asinine, right? It's just a dumb comparison because it's not the same. And I know these people want to make it the same, but it just isn't. There are additional complexities that they're going to have to deal with whether they like it or not at some point. And they're going to keep playing this thing that nobody's above the law. We made this point before. The president literally is above the law. That's why he has the pardon power. That's why, in my opinion, he's got the opinion power, the opinion clause power, the commander-in-chief power, declassification power, all of those different powers. So it's a big deal. Now, the judge continues, living in fantasy land, saying, public has an interest in a fair, timely, and fair justice, which is true. We would like to see some fair justice here. Delay can prejudice, and it is not an uncommon defense tactic. That's true. We delay all the time. All the time. Very true. Doesn't make it illegitimate or illegal. As trial lengthens, witnesses can become unavailable or memory jeopardized. That's true. Yeah. But unfortunately for the government in this case, they have 11.5 million pages of documents. Judge says, I looked at other case law, says, in U.S. versus Burton, D.C. Circuit, counsel is not entitled to unlimited prep time, which is again not what they're asking for. Counsel is entitled to reasonable prep time. So she's citing a comparison case. Just like when you go to house shopping or something. Not that I've ever really done that. But you're looking, you say this one's got a pool, this one doesn't have a pool. What do they cost? This one's got a 2-car garage, this one has a 3-car garage. This is what we do in the law. You take different cases and say, well, what's happening here? So my question in U.S. versus Burton, which we don't have, were there 11.5 million pages of documents in that one, Judge? How about in this one, U.S. versus Cronick? SCOTUS held, they said neither PD of time the government spent investigating the case, nor neither the period of time government spent investigating the case. So it doesn't matter if the January 6th investigation took 5 years. Trump doesn't get 5 years. And the number of docs that the agents reviewed during the probe is relevant to the question of whether a competent lawyer could prepare to defend the case. So what they're saying is they want to separate these two things out. And this is pretty common in the law. They don't want to set a threshold to say, well, you can only government disclose 1,000 pages of documents for DUIs, 5,000 pages for aggravated assaults, and 10,000 pages for murder cases. They're not going to set thresholds. Or if this case has 200 documents, that the defense should prepare for it in 2 days, but if it's got 1,000 documents, they get 5. Like, they're not going to do that game. So they're saying this, the Supreme Court has said that you don't automatically just get more time because of the number of documents or automatically get more time because of the length of time that they used, but it is what is reasonable for the defense to prepare and defend the case, which makes sense logically. Otherwise, you're going to have micromanaging of the cases. But again, in Cronick, my question is, was there 11.5 million pages for the defense? Let's see where this judge takes takes us. The judge says, all right, well, look, and while I'm talking about this, we're also aware that Donald Trump has other indictments and other matters, totally legitimate, of course, and says that Todd Blanche here represents Trump in New York and Florida, and he says that Blanche is going to be here in D.C., so he's very familiar with all of these. He says, so Judge says, I'm going to start addressing the timing of the other cases. And it sounds like Trump's lawyer says, Your Honor, before we start addressing those other cases, I just want to be clear about this, okay? The median time for a conspiracy case in the United States is 29.4 months, okay? Just so we're clear about this. 29.4. You're giving us 7 months to do our case. 29.4 to 7 months. That was from commencement to sentencing, says the government, not trial. Sentencing in this court takes 90 days or more from the verdict. So that statistic is a bit misleading. So we saw this come up. So it's like, so what? So subtract 90 days off 29.4 months. So subtract 3 months. Great. Now what are you at? 26 months? Neat. Still over 2 years. Not anywhere close to 7 months. If the government wants. Sure, take off 90 days for sentencing so your statistics aren't misleading anymore. The judge continues. She says, all right, well, I've also noted, I've read everything. I'm looking through Trump's motion. I see that the cases that were cited by the defense, you guys cited this, they all involved 6 and 17 co-defendants. And there's no co-defendants in this case. So what she's doing now is she's saying that your house has a bigger backyard and this one doesn't. So that's why you don't need as much space over here. It says you haven't identified any case where the defendant was given over 2 years between the indictment and the trial. So she's like, I want to see a specific case. And there's no co-defendants in this case. She says examples used by the defense here weren't quite accurate either because we had COVID. Oh yeah, because of the limitations of COVID. They used COVID to rig the election, and now they're using COVID to rig the judiciary. Isn't that fun? Oh, well, the reason it took so long back then is because COVID and things were slow. But we're going faster now, so now we can go very fast. She says, Trump's people argue that it needs years to review 11.5 million pages in discovery. She says, but the government has already said that a lot of that is duplicative. So it's like you've got 2 copies of that. But the government contends that 65% of the materials that Trump functionally has access to are duplicative. So why did they include duplicates? 65% of that are duplicates. And 25% are from entities associated with Trump and other documents. So they say, well, we rounded up these documents from Trump's organizations. And so he should automatically know what we scraped out of him. And he should just automatically know that the duplicate pages are actually duplicates. He should just trust us. And he should just not look at half of them. He should just not look at 65% of the materials because they're just dupes, which is insane. Okay, that's like actually malpractice for a defense attorney to not look at 65% of the materials and just presume they're duplicates. In thousands of pages, they're from Trump entities and he would have already had access to those. So he doesn't need time for those. So the judge says, okay, Molly, the prosecutor, can you address discovery production notes in your recent motion? How much discovery did Trump already have access to? So they basically are saying that Trump should have been defending himself against criminal charges in a case that hasn't been charged yet. How much of the discovery did Trump already have access to, asked the judge, including items at the National Archives? Molly from the DOJ says, at this point, discovery is now substantially complete, whatever that means. We made a 5th production last night. We are at 12.8 million pages generally. 12.8 million. So it's way more than 11.5. So that's like, we're at like now, I don't know, 10 and a half Washington monuments. Oh my gosh. We're in double-digit Washington monument territory of discovery. But she says, as we described, the number of pages isn't the best metric because we probably have a bunch of spreadsheets and a bunch of things that have like columns that go out into infinity. You know, so if you actually printed out the 1,000 page spreadsheet with columns that go all the way out to XXYYZZ, then you're going to have just this smorgasbord that you'll just dump out of your printer. Your printer is going to be printing all this. She says, just forget it. Number of pages isn't the best metric, but more than 3 million pages are stuff that we scraped from Trump's campaign, which still a lawyer needs to review. So somebody needs to review whatever those documents are. And PACs. There are millions of pages from the Secret Service. Got to go through those. 102,000 pages from the National Archives. Definitely got to look at those. And the judge says, and these would have been reviewed by Trump's counsel for privilege before they were turned over. That's correct. And she says, what's in the other 5 million pages that we're really talking about? Well, there are things like every grand jury transcript in this case up to the indictment and the accompanying exhibits that the defendant has already. It says there are a lot of reproductions in these millions of pages. Same thing true with witness interviews. We got a bunch of duplicates in there. And judge says, yeah, that's what I was going to ask. How much of the discovery could be categorized as witness statements and notes? Molly says, well, give me a minute. She's like, great. Yeah, I'll give you whatever numbers you need to justify this garbage ruling. Flipping through some papers, Chutkan's taking notes. She says, hold on a minute. It's 58,000 pages are from witness interview folders, and that includes transcripts. Most of them were audio recorded. So the defense has been provided with audio recordings and transcripts for convenience of review and all the exhibits used in those reviews. All right, there's the audio. So, and you want to listen to those too. You don't want to just read it, because you can't get all of the tonality in a written thing. And sometimes you'll hear things that are not written. So you've got to listen to that. So 58,000 pages plus all of the time to listen to those in audio format, and then probably read it again. But they said the judge is going to try to preclude them as something that matters. Says those were presented in an organized fashion. And for those of you who are not familiar with Molly Gaston from the DOJ, she is thrilled with her capabilities as a prosecutor, which includes sticky notes, highlighters, paper clips, push pins, and she very much likes to keep things nice and tidy in document fashion, which I appreciate. That's great. But I don't give a crap about that if I'm a defense lawyer and it's coming from a prosecutor. Thanks, Molly. Nobody cares on the defense, but she keeps bringing it up. She says, judge, though, like they're really sticky, like a lot of sticky notes on them. They include the transcript of either grand jury testimony or interview, agent notes, it was in an interview, and then the exhibits associated in any interview report of the interview. It's like all organized. How much of this material is defense created? Like tweets. How much of your 11, 12 million pages are tweets? Well, it says open source would include publicly available litigation. So not sure I have a breakdown of his tweets, but I could get it for you. She says, now forget about the tweets. You said at least 25, judge speaking, you said at least a fourth of the first production and 20% of the second production. They came from entities associated with Trump. You mentioned a PAC. What else? She's digging. What else can I say he's already got access to? Well, there's the defendant's campaign, Trump, a few PACs that we scrape through. In terms of open source materials, she's grasping here, including campaign statements, tweets, True Social posts, about 27,000 pages, judge. And she's like, oh man, I was hoping that was a much bigger number. Like, she's like, I was looking like a ballpark of like millions, not 27,000, like millions. So I could say Trump already had all that crap. Gaston continues, Molly, she says, Your Honor, key documents are 47,000 pages, and that includes all the case agent summary testimony, pretty important stuff, exhibits introed through her to grand jury, includes things like transcripts, witness testimony, all of it. It's a file that's essentially an annotation of the indictment, and that's almost 300 different docs that are labeled and named according to the paragraph of the indictment that they support. So it's essentially a roadmap to our case, Your Honor, which is, I'm sure she feels great about that. It's like, Molly, put that on your refrigerator at home. Okay, that's neat. Hang it up, bring your parents over and your other prosecutor friend, and you can all look at your little mind map. Okay, I'm a huge mind map fan. I love roadmaps and mind maps and all this stuff. Okay, I'm a big fan. In fact, I'd like to see it. Of course, we'll see it come out here. But as a defense attorney, and from our perspective, your roadmap to your prosecution is irrelevant to us. It's insane that this is even being discussed. It's like the defense attorney has got to be laughing right now. He's like, I don't give a crap about your roadmap. Do you think they're going to follow it? Like you're giving the defense all your best materials going to the defense attorney? It's like a joke. Gaston also notes how all of this is in a nice searchable database for Trump to review. The judge says, well, this is really a great presentation. I love this. Fantastic. This has answered most of my questions about discovery. Sounds like discovery is substantially complete. And she says, I just absolutely love how highly organized it is. Your sticky notes are outstanding. You've done a great job, Molly. Sit down. Molly's like, ooh, yay, judge likes me. The judge says, okay, I'll note now that many years ago, when I was trying a murder and conspiracy case in Superior Court, we got witness names on the date of trial, is what she says. Right, now here we go. And testimony in grand jury sometimes after a witness testified. Rules here provide far more disclosure. So she's talking about her time as a prosecutor. When she was trying murder cases, presumably this is her talking about her being a prosecutor, we got witness names on the date of trial. So she's saying, I got to prepare very fast, making the point that they go quickly, so you can go quickly. Rules here provide for far more disclosure. And sometimes I don't get evidence until it comes out. Okay, so stuff just happens fast. I think it's the point she's trying to make. In this case, we have far more disclosure than even I had, right? Things were bad when I was doing it. Now it's a lot better. The manner in which the discovery has been organized organized by the government. She bit on it, okay? The government threw this at her and she bit on it. Ah, Molly, well done. Those highlighters, man. The government has made a considerable effort to expedite review, certainly beyond their normal obligations. Yeah, the government went above and beyond. There's sticky notes, highlighters all over the place. Prosecutor did a great job, gave the judge exactly what the judge needed to say that you don't actually need to review anything because the government, the people who are prosecuting you, they reviewed it for you and they organized it for you to show you how they're prosecuting you, so you don't even need to read the evidence. And says, so it sounds like it's all very organized. So she says, okay, Mr. Defense, what's your problem? Why isn't this enough time, Lauro? Lauro is fired up. Okay, I can't even imagine. I'm fired up right now. She says, Brandi says, Lauro is coming in hot, which I can't even imagine, man. Because it's these two people are talking about their highlighters, honestly. About 11.5 million pages, a small portion of everything we just read through, 27,000, 57,000 pages, a small tiny dent in the max amount of the documents is from actually Trump's. The rest, 65%, it was just duplication. And it's all nice and organized with a roadmap. So the defense is like, probably going to be charged with murder in the courtroom, any minute. Doesn't cross that line, fortunately, but his voice is raised a bit. He says, Your Honor, President Trump is here as a part of a show trial. We have to do our job as defense lawyers. For a federal prosecutor to suggest that we could go to trial in 4 months, which is what their original request was, is not only absurd, but it is a violation of an oath to justice, Lauro says. Voice is booming. Raged. He's absolutely right about this. It should be misconduct, right? If we lived in a society where prosecutors cared about justice, unfortunately we don't. And I hate to, burst that bubble for anybody out there who still thinks differently. And this would never happen. A prosecutor would never do this. And every single person who's involved in this case, I would imagine that every prosecutor who's even watching this, who's being honest with themselves, says this is insane, okay? 11.5 million pages. Prosecutors don't even want to read a 50-page police report, for crying out loud. So 11.5 million pages, they know what this is. This game of patty cake back and forth between the judge and this prosecutor, literally talking about organization. 11.5 million documents versus being organized by the government. It's insane. It's outrageous. So he should be upset. The judge says, hey there, John. Let's take the temperature down here a notch, okay? Defense Lauro says, Your Honor, Trump stands before you here today an innocent man. He's entitled to the 6th Amendment, which is right to counsel. He's entitled to counsel that can prepare adequately. What this case means, we're talking about 9 terabytes of information. I have to go through it. I have to sort it by more than 250 witnesses. I need to think about corroborative material. For the government to suggest that I can do that in 4 months is an outrage to justice. Not once have they talked about justice. They can give me key documents in this case, and that's very kind of them. Judge stops him. You're getting a little bit too preachy over there, defense attorney. I'm going to need you to take the temperature down. Her voice is even and calm. She says, Trump is not like every other defendant, given access to his lawyers and resources. Okay, so now Trump, this is incredible. So now Trump has privilege, so he can deal. Like she's justifying he's a privileged person. He's got more resources so he can read faster. His lawyers can read Tolstoy faster than other lawyers. He just needs to get 78 of them. And given that much of this has already been reviewed by Trump or his team and turned over, it can speed up review. Lauro says, Your Honor, we as criminal defense lawyers have not had access to what is in the National Archives or the Secret Service. But she says, but some of that material is not new to you. Says, how is it not new to him? Judge says, because he's saying like anything that comes from them is new to us. Anything that's in the government's file, I don't care where they got it. They could have downloaded it from Trump's cell phone. I don't care. It's new. So some of these statements, this is the judge, are of your client's own creation. You personally, it may be new to you, but this material that has been reviewed at least by privilege, and some are statements of your client and materials created by your client or entities associated to him. So that's not brand new information, is it? Lauro says, of course it is. And he's absolutely right about that because it's from the government. It's all from the government. It's not like Trump gave it to them. This is called chain of custody. It's the same reason we question what the government does when they take the blood out of your body and do something with it. We don't just say, oh, well, whatever they came up with is like a reasonable thing. And if they give it because it was our blood, like we don't need to defend it against it or something since we already know what's in it or something. And since they took it and assembled it and did some analysis on it, that they're done. we're done. Oh, well, I guess the blood came from us, so we should just accept it when they test it. They took these documents and assembled it, and the judge just says, well, you've already kind of seen it, haven't you? Absolutely not. Says there's a lot you may personally need to eyeball, this is the judge, of 11 million pages, but you at the first cut, you personally are not going to review 12 million pages. Obviously not. It's impossible. Some of those documents are going to be reviewed electronically. Lauro says, Your Honor, no documents get reviewed electronically. We can do searches for it that way, but we're not going to do that. He's telling Chutkan to explain the file searches. He says, I like to be prepared for trial. I like to get my exhibits open and all the things. He says, look, Your Honor, if we were a big corporation in America where the only thing at stake is money, no one would even blink an eye for a 2-year delay. But this man's freedom is at stake. He's very emotional. Judge says, I understand, but you're not getting 2 more years. This is not going to trial in 2026. Says the grand jury investigation has been ongoing for more than a year, which makes good point. So why would the trial happen in less than a year, in 7 months? Defense says, Your Honor, we can't be charged or hindered because we couldn't do an investigation during the grand jury. What do you want us to do? Chutkan rests her head on her hand for a very brief moment as she listens to Lauro. Oh gosh, she says, oh gosh, this Trump defense lawyer. Ugh. She says, I'm asking you to review what's necessary in this case. I'm well acquainted with Gideon and Trump's 6th Amendment rights. I intend to ensure he gets it, but I'm not going to give you, this case is not going to trial in 2026. And I'd like you to know that given the rhetoric in your response, realistically, how much time it's going to take you to prepare. You've known this was coming, and a lot of this material was in Trump's hands, not that much, or in counsel's hands for a significant period of time before the grand jury was convened. You keep talking about 12 million pages and his right to a fair trial. He has a right to a fair trial, but what is fair? What is a fair amount of time to prepare? And the 12 million pages here is not actually truly indicative of how much time he needs to prepare. Lauro's fighting with her. She keeps telling him, you're going to be given reasonable time, but not 2 years. Says, I'm pleading, Your Honor, this is a question of one man, one U.S. citizen gets a fair trial or not, and I'm telling you, it's a gargantuan task. I understand we have modern search tools, but none of this takes into the consideration the work the defense has to do to prepare its witnesses or materials. We have to ensure the system works for every American, Your Honor. Trump should not be treated any differently. We cannot be ready under the circumstances of this case until we have a reasonable amount of time under the system of justice. Judge says, Mr. Lauro, I have no doubt that you're capable and that you want to provide Trump with capable representation, but you're not going to get this length of time. And he brings up novelty, and she says, what novelty? Says, it's not that novel. It's just a conspiracy charge. A former president being charged is historic, but the alleged conduct, they're not that complex. So why is this case complex legally? I don't know. Good question, Judge. Maybe 11.5 million documents, 12.8 million documents. Maybe that's one reason. Lauro says, are the other cases, do they involve 11.5 million pages? And that's just the start, right? That's just a symbol of the gargantuan amount of discovery. Lauro says, we also have subpoenas. There will be a selective prosecution motion filed, given that the prosecutor's boss is running a presidential campaign. That makes the case novel. We've got some conflict of interest problems. Says, we're going to be busy with very complex legal issues. This is one of the most unique cases from a legal perspective ever brought in the United States. Now, Molly comes back up. Molly says, I think there's a reason Mr. Lauro avoided answering your exact question about when trial should start. He doesn't want to admit, she's the highlighter label gal. He doesn't want to admit that search tools in modern criminal trials mean it's possible to be ready much sooner. She says, Trump posted many videos and messages online addressing this probe, showing he knew it was coming. So he should have been preparing before we even indicted him. He said the night the indictment was sealed, Mr. Lauro called the indictment a regurgitation of the January 6th committee report. So she's now saying that our committee or our prosecution is very similar to the committee report, and Lauro criticized that. It also says Trump has 4 lawyers and also 2 lawyers who attended the arraignment. Trump's lawyers went on air. He went on podcast. He described the number of motions. He said he read Mike Pence's book twice and he knew what witnesses to call. And so the best way to find out if the defense can meet the standards for trial prep is to set a schedule and see if they can meet it. So just set it and they'll figure it out, Judge. We're ready. Who cares if they're ready or not? Says selective prosecution motions are not novel in DC. You know this, Judge. So these are 2 people who just are probably, they're playing patty cake. I'm sure Your Honor knows this. Fraud, conspiracy, not new, not complex. The thing that we need to do is set a trial date. Trump, formerly the senior most official in our federal government, is accused of historic crimes, attempting to overturn the election, disenfranchise millions of people. There's a strong need of public interest to hear this in open court and proceed to a fair trial. Yeah, and they let this guy out on release. She notes that Trump continues to disparage the proceedings. as he should, potentially intimidates witnesses, which is, I don't agree with that at all. She's saying he potentially mucks up the jury pool as a result in DC. So as long as he keeps talking about this, it's going to wreck what we're doing here. As more and more people realize how illegitimate it is, I agree with her. The small amount of classified materials in this case doesn't matter. We're going to be able to burn through that. We're going through the classified document steps, and we'll deal with it. Now, Todd Blanche is up for Donald Trump. He updates the judge on security clearances, and Laura's back up. He says, we're filing more motions to dismiss and other things. Judge takes a brief recess and he comes back. She says, all right, look, I understand all too well the need for counsel to have enough time to investigate and prepare for trial. That need is even more compelling in cases like this, where the defendant faces serious charges and penalties. I take seriously the request that he be treated like any other defendant, and I tend to do so. But I also want to point out that most defendants, she says, look, most defendants do not receive this organized summary of discovery. That's what she's hanging this entire case on. Her stinking highlighters. Nonetheless, January 2nd doesn't give enough time, but 2026 is way too far. These offenses occurred at the end of 2020, beginning of 2021. To try it 5 years later poses real danger to the witnesses. Well, hey, judge, you do know that the government chose to bring it today. They're the ones who waited all this time. So why are you penalizing Trump? Chutkan says it's in the interest of justice to speed this up, but we can't do it while stripping Trump of his rights. The grand jury in this case convened in September, meaning Trump has known about the government's investigation for a year. I guess he should have been investigating crimes he didn't know were coming and crimes he didn't know what they were. I've seen many cases delayed because of a lack of representation, but that's not the case here. And so she says, I'm deciding, given all of the things that I've seen here today, including these tremendous sticky notes, Molly, you did a fabulous job. Trial, March 4th, 2024. She said, I've consulted with some competing cases, and that means this trial is going to start 3 years after January 6th. Lauro stands up. He says, okay, Your Honor. Yeah, that's fine. I mean, we'll be here ready for your trial, but this date will deny Trump effective assistance of counsel. So we'll be here for your trial, but I'm just letting you know, we're not going to be able to do our job, and our client is not going to have effective assistance of counsel. You're violating his Sixth Amendment rights, just making that on record. Because I note your record. What does she care, right? The Court of Appeals in DC, what are they going to do? A pretrial schedule will be made. I'm going to issue a minute order. As Your Honor, defense says, we want to move this case out of Washington, DC. Says, I'm not inclined right now to do that. Says, I'm watching carefully what Trump is saying for anything that might affect the jury pool or poison that jury pool. If you file a motion to transfer and you haven't, but you're doing polling on the other, it might affect the same jury pool you're claiming is not fair. So she's saying, look, like Trump's general criticisms, if they impact the DC jury, it might also impact wherever you want to transfer the case to. So be careful about what you put in that motion. Says, you may actually affect their ability to render a fair verdict. Are you intending to do this polling? We're going to wait till we get closer to trial. And boom. Judge says, we're not treating Trump any differently. Trial is scheduled March 4th, 2024. So pretty incredible. The judge just doesn't really care about now 10.5 Washington monuments. He says they're nice and organized. They've got sticky notes and labels. Molly Gaston is doing a great job. Trump's defense doesn't need to really read anything, and trial can be scheduled right in the middle of the primaries, one day before Super Tuesday. You see, he's scheduled for March 4th now. Super Tuesday is March 5th. We've also got his classified documents trial starting in May. So we've got the Georgia trial, whether that gets removed or not, we'll see. The final trial date is there as well, all in the run-up to the November 5th election of 2024, because these people want their opponents off the field. Now, this is Alina, Habba, who is on to explain to us how they're preparing for this, which is not much because they don't really need to prepare for the truth.
Let me ask you this, the logistics, you saw the timeline there. That's in the middle of running for president, caucuses, primaries. How do you logistically handle, prepping a client for all of those different trials and running for president of the United States?
Yeah, if it was a normal person, honestly, Shannon, I could understand the concern. President Trump is not your average person. He's incredibly intelligent and he knows the ropes. He also knows the facts because he lived them. These are not complicated facts. Look at Fannie. It was a phone call that's been around forever that he refers to as the perfect phone call. What is he going to have to be prepped for? The truth? You don't have to prep much when you've done nothing wrong. So that I'm not concerned concerned with. These trial dates also are going to move. It's unrealistic, it's theatrics, and no judge is going to say that you can be on 2 trials at once in 2 different states, because a lot of these overlap. They look at the start date of the trial, but these are 4 to 6 week trials at the least. So there's no way they're not going to overlap. I mean, they're going to have to go into October, November of next year, again, by design. But in terms of President Trump, the candidate, I have zero concerns.
Okay.
Look at his poll numbers, and he didn't even go to the debate.
Yeah.
Look at Fannie. She is absolutely right about that. Big Fannie Willis out in Georgia saying we don't need any trial prep because there's nothing really to defend. It is all truth and honesty ahead. And, you know, there's some truth to this. I mean, I really don't know. In some of these jurisdictions, in some of these forums, I don't know that there's anything that Trump can do. And I don't know that I agree with her that these trial dates will move. I mean, I think that they'll move, but I think that they have a end game of having the trials occur before the election. They want a conviction before the election, and they're going to do whatever they can do to get that done. So we'll see. This is what they are up to. Insane trial date for Donald Trump, March 4th, 2024. Of course, we're going to continue to cover it. Things are going to go fast, my friends. We're going to see a slurry of motions from Trump in response to this, because this, of course, is insane. And of course, we'll continue to cover. Thank you for subscribing and joining along as we do, and we'll look forward to seeing you on the next one.